call to see how many members of the committee we have with us today. If you are a member of the committee, please disable your camera at this time. And if it becomes necessary to have you address the committee, I'll ask you to start your camera at that point in time. Attorney Del Campo?
Yes, Your Honor. Justice McDonald's here. Judge Chaplin?
Present.
Judge Farley?
Here.
Judge Hernandez?
Present.
Judge McLaughlin?
Here.
Judge Nguyen O'Dowd?
Present.
Judge Pearson?
Present.
Judge Prats? Judge Stewart?
Here.
Okay, well, first of all, I'd like to welcome the new members of the committee who are joining us for the first time. We appreciate having you join us. That would be Judge Pearson, Judge Chaplin, Judge McLaughlin, and Judge Stewart. So welcome. We look forward to a good and productive year. The first item on our agenda is the approval of the minutes from the May 9th, 2022 meeting of the Rules Committee. I would accept a motion to approve by one of the members of the committee who was on the committee in May of last year, which was our final meeting.
Judge Hernandez so moves.
Thank you. Is there a second?
Second.
Second.
Seconded by Judge Nguyen O'Dowd. Are there any changes to the minutes from that meeting? If not, for the members who were present, who are on the committee last May, please signify by saying aye.
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 Are there any opposing views to approval of the minutes? I will, so that passes with the 4 new judges not participating since they were not members of the committee at that time. The second item is 2021-23, which was a proposal to amend practice book section 7-10 and 7-11 regarding the retention and destruction of summary process records. This item had started with us, I believe, in December of 2021. And I would ask for the benefit of the new members of the committee, if Attorney Del Campo would give a brief overview of what the proposal is and its history up to its inclusion on our agenda today.
Yes, Your Honor. As you indicated, it was received in December of 2021. It first went on the committee's agenda December 13th, 2021. The proposal requested that all identifying information regarding evictions resulting in withdrawal, dismissal, non-suit, or judgment for the defendant tenant be removed from the judicial branch website as soon as administratively feasible, but no later than 30 days following disposition. And that identifying information about all other summary process matters be removed within 1 year. The second part of the proposal was that a new practice book section be enacted requiring commercial purchasers of judicial branch data agree to disclose only the most recent version of these records. And that would be in keeping with the current judicial branch user acknowledgement form. In February of 2022, or no, I'm sorry, in December of 2021, it was referred by the committee to Judge Carroll on behalf of the Judicial Advisory Committee on e-filing to see if they would take up the matter or should take up the matter. They reviewed it in January of 2022, sent it back to the Rules Committee indicating that the Rules Committee should, it would be better if the Rules Committee took it up rather than that committee or the legislative authorities. And that came back in February. It was on the agenda. It was then referred out to court operations and Judge Abrams and different landlord associations for comment. Again, came to the agenda, came back to the committee in March of 2022 and was again tabled pending the outcome of Senate Bill 200, which was on the subject matter. So the committee wanted to wait to see what the outcome of that Senate bill was. In May of this year, May 9th, it came back to the committee on the agenda with the status report that Senate Bill 200, I hope I said, the Senate Bill 200 had had not passed. And then the committee tabled the proposal until now in order to try to understand why Senate Bill 200 did not pass. And on the agenda, you'll see items L, M, and N are new materials. They consist of some comments in support of the amendments, a letter from legal aid associations concerning why they think Senate Bill 200 did not pass, and we put together for you all of the public testimony of Senate Bill 200.
I appreciate that thorough review. Is there anybody from Greater Hartford Legal Aid or one of the legal aid groups who proposed this with us today? Do we know?
Yes, this is Raphael Podolsky. I'm here. Can you hear me?
I can, Attorney Podolsky. 1 second.
I should also say Attorney Giovanna Shea, I believe, is out of state, and we requested permission for Attorney Elizabeth Rosenthal from New Haven Legal Assistance to be here with me, and I believe she's also here.
Perfect. Thank you very much. Attorney Rosenthal, if you could enable your camera. So let me just first ask, I'm a little concerned that this, I know how the legislature works, but I'm a little concerned that there was a bill that was acted favorably upon in committee and didn't ever get called in the House or the Senate. I understand that doesn't necessarily reflect on the merits whatsoever. I fully acknowledge that. I'm a little concerned if the committee thought it was relevant enough for them to act on it through legislation, whether we would be better served in waiting to determine, to see whether that is something that they still intend to proceed with. This is a little bit more substantive in terms of policy than we normally look at in a rules committee meeting, and I'm very sensitive, and I think other members of the committee are as well, to deferring to the legislature on issues of policy whenever possible. So I don't know if you'd like to give us an update about whether or not there was any plan to reintroduce this in the legislature come January.
Well, let me answer as best I can. The letter from the legal services programs that's in the new information category, we attempted to explain what we could. I mean, obviously, we're not legislators, and we are not authoritative on what the legislature decides to do. But we spelled out for you as much detail as least we felt we could about our perception of what happened. The bill did pretty well in committee. All Republicans on the committee voted for it. There was no partisan division. It was not a unanimous vote, but there was no partisan division. The bill, however, was not drafted properly in relation to bulk purchasers, as well as some other issues with the drafting. But the bulk purchaser issue was a significant one because the assumption had been that what bulk purchasers are buying, for example, these are like tenant screening services or credit bureaus, what they are buying is the database as it appears on the online website. So that if, for example, something's removed from the website, that it will not be available to bulk purchasers. And so the focus of the original bill had been on controlling what was on the website for that purpose. It turns out that's not, in fact, the case. Judicial, of course, maintains a permanent database. They don't erase. Judicial doesn't erase the data when something is removed from online. But what they market, what they sell to bulk purchasers is not the online database, which would have cases removed over time. Even now, cases that are on for 3 years, they are actually still on indefinitely when the database is sold to a screening service. The result of that is the bill had to be revised to accomplish that, and trying to do that in a way that would not impose costs on judicial resulted in lengthy conversations and delayed the bill. And I think if you talk to the committee chairs, you would discover that was the case. By the time the bill was at a point where it might be ready to go, there were only a couple weeks left in the session, and the Housing Committee had two major bills that were subjected to extensive debates that the committee, I think, was not in a position to call up any other bills. And I think if you look, you will discover that after at a certain point, the legislature had moved on to other bills. I think it's our intention to, I mean, the dilemma for us has been with this particular issue, we believe it's well within the power of judicial, not only through the Rules Committee, but actually just administratively, to resolve this issue in-house. But it is also a policy issue because of the reason why the time available generally to the public might change. And so that I understand it makes sense, certainly makes sense for us to look to the legislature. So we're sort of in this time bind that if we go to the legislature, and we've also gone to judicial, somebody could say, oh, well, judicial is going to take it up. If we reverse it, then it sort of plays out the opposite way. And the timelines are different because the legislature has to be done by a certain date. Judicial, it's really sort of a one-year process in judicial because it goes through the meeting of the judges during the summer. So I think we would try and ask the legislature to bring the proposal back, unless it seemed like that wasn't a very smart thing to do, quite frankly. We did not get the feeling during the session that they didn't want to move it forward. In fact, we had the opposite feeling. But, and again, I cannot authoritatively speak for the chairs of the committee. But that was the reason. That was the reasoning behind this. We would be happy if simply as an administrative decision, you made certain decisions about the marketing of the list and the time it's on the website, because we were led initially to believe that the time on the public website was linked to practice book 710 and 711. But
Okay.
there's no reason it has to be.
Let me stop you there. I'm somewhat concerned that especially the new members of the committee have not had sufficient time to look through all of these materials. I don't know that for certain, but I am concerned about that. But let me ask you this, Rafi, given the fact that there will be a new legislature, and I don't know if the co-chairs of the Housing Committee are going to be new co-chairs once that new session starts, but would it not be advisable for us to wait for one of two things, either to find out whether or not the new co-chairs of the committee, whoever they may be, are interested in this legislation and if they intend to move it forward, and two, to get definitive input from Chief Court Administrator Judge Carroll. He gave us a response previously in his capacity, I think, for the e-filing committee, but what you're identifying is not an e-filing committee issue. It's just whether he has a interest in doing this administratively, in which case we wouldn't have to take any action. Would either of those be palatable to you?
Well, I get, here's what let me tell you what I think would be preferable that sort of takes that into consideration. The first thing is that we had initially gone and spoken with the Chief Court Administrator's office and with External Affairs, and they had said that they had told us to go to the Rules Committee. So it certainly makes sense for you to talk to Judge Carroll, but I can tell you that the view that was expressed to us was that he felt it was a policy matter, and therefore it should be handled either by the Rules Committee or by the legislature. So there's no reason for you not to talk to him about it. Obviously, that makes sense. But I think that's likely the answer that you would get. I think you're correct that we don't know. I mean, we don't know who's going to run the legislature after the election. We don't know who the committee chairs are going to be. My suggestion would be that the committee should put in place the preliminary work that you need to do if you were going to move forward on this. That's to say, if there are entities or people you want to vet it to, you should gather that information without waiting, even if you decide that you want to do any waiting before, so that you would be in a position, if you choose to move forward, that you could do that. And I'm not quite certain from what you say, whether the answer from, let's say there are either the same or new legislative chairs, which way the answer goes in terms of how you would proceed. If they say they're interested in doing a bill, would that mean that you would then wait? If they say they are not interested in doing a bill, would that mean you will go forward, or would you then decide to wait or not do it? Because if they're not interested, why should you be interested? I don't know where that leads. And so my preference would be that you do as much as you can in getting ready, regardless of what happens. And I understand that you've got new judges on the committee, and that they're not, you would not be in a position to act on this today in any event.
Okay, I do have a couple of suggestions, but I want to open it to other members of the committee if you have any questions for Attorney Podolsky on this matter. Judge Farley? It looks like you're...
Well, I think, to be fair, I ought to, at least speaking for myself, tell you where I think I am on this. The judicial branch, our records are open. We make exceptions to that on an individual case-by-case basis. And what's being proposed here is that there's an overriding interest, which is the concept that we apply, but that it's on such a broad scale that I really feel it is an issue for the legislature. So, if the legislature gives this full consideration and says no, I would be inclined to say no. And I just wanted to, because you raised that issue, I think at least one member of the committee, and that would be my inclination.
Any other comments from members of the committee? I would say that Attorney Rosenthal.
I don't want to interrupt any members of the committee, and I appreciate your time. I would like the opportunity to say one thing before we conclude on this matter.
I don't think we're concluding quite yet, but let me say, for my part, I would be loath to do anything. I mean, I'm not opposed to getting additional input from other stakeholders. That'll also give new members of the committee some more time to go through these somewhat voluminous materials. I would really not feel comfortable moving forward in any substantive way without having the input of at least the new co-chairs of the Housing Committee, and we won't know that until January, most likely. So I have no problem keeping this, on our agenda. I guess I would want to know. Well, let me ask you this: do you think that I don't even know who it is anymore, what the Commissioner of Housing thinks on this subject? Have you reached out to the Commissioner?
I don't know that we've had a specific conversation on this. I think that the Commissioner of Housing is supportive, but I don't think the department has taken any formal position. They did not testify at the legislative hearing. We can certainly find out.
How about
sure.
this? Why don't you do that? I will talk to Judge Carroll. It sounds like, and I definitely understand the predicament you're in, but it sounds like they originally thought that the Rules Committee would have a role in this under the practice book, but it sounds like they're actually selling something far beyond what the practice book requires to be held, right? They have more extensive data that's part of the large-scale sale. Is that right?
My understanding is that the database, I don't know if there's any termination date, but the database goes on well beyond 3 years. And it's my understanding that it's whatever that permanent database is that is sold, not so that things that have been removed from the public database are still sold under the status quo to
Okay.
businesses to buy bulk data.
Unless other members of the committee have a strong feeling on this, I would recommend that Attorney Del Campo ask the Commissioner of Housing for input about the proposal, and that he and I and any other member of the committee who wants to participate, obviously, set up a meeting with Judge Carroll to find out whether this could be done administratively and not necessarily through a rules change, and then we could report back to the committee at next month's meeting. Does that proposal sound good to the members of the committee? And I will take silence as acquiescence as well. Okay, so we'll do that, and then we'll have this on for our agenda for next month. Okay. Thank you very much. The next item on our agenda is 2022-006. It's a proposal concerning Rule 2.11 of the Code of Judicial Conduct. We're going to have to pass that because I think that's the one Attorney Del Campo, tell me if I'm wrong, Judge Prescott had wanted to participate, but he's on the bench right now. Is that correct?
Yes, Your Honor. Okay,
So we're going to pass that. We're actually also going to pass the next item, which is the 2022-009. That's a proposal from Judge Abrams. He could not join us today, and he's asked us to put off that very minute, small matter to another day. So our next item that we'll take up is 2022-010, proposal to amend practice book section 7-11 to allow civil protection orders to be retained for 5 years as opposed to the current 10 years. Attorney Del Campo, this is the first time on our agenda.
Yes, it is, Your Honor, but it did come from Judge Abrams when he was Chief Administrative Judge for Civil Matters. Now Judge Bellis is. She has not had an opportunity, at least from the documents, to opine on this. So yes, first time being considered, has not been sent out, but typically when the CAJ send it, they do a lot of vetting beforehand. But Judge Bellis certainly hasn't gotten it, I don't believe.
So what we would, for the newer members of the committee, what we would typically do here, it's a little weird because we have a change in CAJs, but I would want to have Judge Bellis's input on this as well. Attorney Del Campo, can you think of any other stakeholder who might want to be solicited for input on this proposed rule change?
Well, overall, I guess court operations is typically asked for their opinion on such matters. This would impact them, I suspect.
Do any of the other members of the committee have suggestions about any groups, entities, or individuals that might want to weigh in on the proposal?
Courtney Chaplin here. I'm not sure if there have been any victim advocacy groups that have been contacted around this issue, but I think that would be helpful knowing this was a recent amendment to the statute.
Suggestion to Chaplin. Maybe we could ask both the Office of Victim Advocate and the Office of Victim Services if they have any suggestions or concerns with the proposal. Anybody else? All right, we'll get those requests out soon. And Attorney Del Campo, do you think we have enough time to get those comments in for us to take this up at our next meeting, or should we push it off for another month after that?
I think November would be better, Your Honor.
Okay, let's do that if there's no objection. The next item on our agenda is 2022-011, proposal to amend the practice book to eliminate the requirement for original printed deposition transcripts and to permit service of civil complaints by consent. I know this is on our agenda for the first time. I don't know if Attorney Goodbaum is with us. Do we have that, Attorney Del Campo?
I don't believe so, Your Honor. I don't believe that he was invited because this was first time being considered. It came individually from him. It doesn't seem to have been vetted around. So I would suggest again that Judge Bellis would like to take a look at this.
I agree. I have to say the second one, I don't know that we even have any jurisdiction over it. My recollection is that there's a statute that deals with the service of civil complaints and the process by which those have to be done. So I think, unless anybody has a different view, I think that second portion of the proposal about doing service of complaints by consent needs to be something that this proponent takes up with the legislature directly and not with the Rules Committee. Does
You're-
anybody disagree?
I don't. Justice McDonald, you're absolutely correct about the statutory basis for service. I'll also say that service of civil complaints by consent, it's a small piece of it, but it does overlap with this whole idea of the federal rules of civil procedure being adopted. A topic on which in which I have great interest, and I'm sure many others do too.
Okay, so we'll maybe you can let Attorney Goodbaum know that we will be asking for input from Judge Bellis on the first portion, but that his concern about the service of civil complaints is better suited to a proposal at the legislature. And then we'll hopefully have Judge Bellis's input for next month. Are there any other questions or entities that people think we need to shop this around to for that first portion?
Wouldn't we have to ask the bar about this too? I mean, you know, really affects them the most.
Judge Farley makes eminent good sense. I would think that we should send it to the Bar Association, probably both, also the Trial Lawyers Association and the Civil Defense Lawyers Association. Is there any other group that you think would want to put their oar in the water? Okay, we'll start there and see where it leads us. So then the next item is 2022-012. It's a proposal for a new practice book provision related to attorney conduct and bar issues surrounding the decision in the Dobbs case. Attorney Del Campo.
Your Honor, this is, again, first time being considered. This came directly from Attorney Logan individually, I believe. So there is no other entity that has looked at this yet. I don't believe Attorney Logan at this point has been invited. Typically, it's, you know, at some point that you're going to consider the merits. But that's the state of this, again, first time being considered. No one has looked at it.
Thank
Do
you.
have with us, I believe, Office of Chief Disciplinary Counsel was called in to look at this, as was a statewide grievance committee representative. But at this point, you know, no one has, it hasn't gone out to anyone. Okay, before I go any further, let me ask members of the committee, is there any interest in pursuing this in a formal, substantive way? Is there an identifiable problem that people think merits our attention at this juncture, or no?
Well, to that point, I had a question, and that is, I mean, I've read newspaper articles that Texas, certain major law firms that operate there have had threats leveled at them, but have they actually, has that state or any other state actually changed its bar admission rules or bar disciplinary rules for this issue? That we would, you know, because to me, I read this as a response to something other bars are doing, that, you know, we might have somebody that's admitted in this state and one of those states, but if no one's doing anything yet, I don't know that there's a need for this.
It's generally my feeling as well. If anybody has a contrary view, please let it be known now. Otherwise, my inclination and recommendation would be that we would table this for now, and until such time as a clearly identified and present concern is brought to our attention, not a theoretical one. Is that acceptable to the members of the committee? All right. Again, taking silence as acquiescence. I appreciate it. The next item is 2022-013, proposal to amend practice book section 2-79D to change the way past due fee notices are sent to attorneys. Attorney Del Campo.
Yes, Your Honor. This was submitted on behalf of the Client Security Fund Committee by its attorney, Christopher Blanchard. It's a change that would actually save a good amount of costs and would become consistent with other ways that the practice book has developed in terms of MCLE and attorney registration delinquency notices. So they would go out by, I guess, first class regular mail as opposed to certified mail return receipt.
Okay, I mean, I have a couple of questions, but I am a little concerned about the notion of sending things by email if they get caught in a spam folder or something. I mean, the consequences can be significant. I tend to not have a great deal of faith in first class mail even these days. So I'm a little concerned about it, but I guess I want to test the waters with members of the committee about how you would like to proceed. Judge Farley?
Yeah, I'm on the the Security Fund Committee. It is an important issue to the committee, given the amount of money that is spent. And, I guess, the alternative would be to change the other rules to require, first class mail, et cetera. I think that this, if it's good enough for our other, in other contexts, it ought to be good enough here. I think we should pursue it, put it that way.
So I needed to hear, we'll at least get the ball rolling. I'm sorry, it looked like Judge Stewart was going to say something.
Well, I actually had a question on this. I mean, if it's a multi-step process before people start getting sanctioned for not paying their $75 or whatever the going rate is, I mean, would there be a way to save money by doing the initial mailing of, oops, you forgot to make your payment by email and first class mail, and then only resort to certified mail for people who don't respond to that first round of reminders? I don't know, Judge Farley, whether you have any thoughts on that. You're muted.
Yeah, the only thought I have is a question I don't have the answer to, which is, how much that would mean in terms of the financial impact on the committee. I don't know how many follow-up notices are necessary. So it's a good idea. It's something we could find out, whether that would be helpful.
Note that in the cover letter, they indicate that the fund was recently charged over $20,000 for the second past due fee notice for the calendar 2021 year. So it's not an insignificant amount of money. Attorney Del Campo, is there anybody, would we need any input from the statewide bar council or Attorney Bowler?
Attorney Blanchard is the counsel to the Client Security Fund Committee. We wouldn't need any more than his. I believe Attorney Harrington is on the call, but who may give us some better information. But no, and this would be the person with Judge Farley's assistance, obviously, and Chris Blanchard, which I don't believe he's not on the call though today. He wasn't called in.
I'm sorry, is Attorney Harrington on?
He was. Let's see if she is. I don't believe so.
Why don't we push this off for a month and ask both Attorney Harrington and Attorney Blanchard to join us for next month? And just before we just ask them to join us, in addition to the information that Judge Stewart wanted to get, is there any other information we would want for them to have to talk to us about this proposal next month?
Well,
Yep.
I wonder what the experience of the grievance committee is under 2-27B. Because they just, send their notices by email and regular mail. And it might be valuable to know whether that's working.
Okay.
Suggestion. Thank you very much. Okay, we'll push that off for next month. This is how we start at the beginning of the year. We actually get around to doing more substantive things in the coming months. Okay, the next item is 2022-14, proposal for a new practice book rule that establishes the procedure applicable to motions for post-termination visitation filed within the context of termination proceedings. Attorney Del Campo, this is from Judge Westbrook.
Yes, it is, Your Honor. It's first time being considered, but Judge Westbrook is here, so I will defer to her. Please.
Thank you,
There she
Attorney
is.
Del Campo. All right, good afternoon, Justice McDonald and members of the Rules Committee. So before the committee today is a juvenile rule proposal on motions for post-termination visitation that's consistent with the Supreme Court's decision in Anessa J. and Ava W. I have conferred with the stakeholders, specifically Assistant Attorney General Stephen Vitelli and the Office of the Chief Public Defender Susan Hamilton, and I utilized their input in proposing this rule. The rule sets out the requirements for practitioners to file a motion for post-termination visitation, and the rule requires that the court hold an evidentiary hearing to determine whether post-termination visitation is necessary or appropriate to secure the welfare of the child, and the rule establishes some factors that the court may consider. So I thank you for your consideration, and I'm available for any questions you might have.
Folks generally familiar with the two decisions Judge Westbrook has identified. I authored them, but I want to make sure I have not, in truth, I have not tracked this directly against those opinions. Are you confident in it? Let me ask you, Judge Westbrook, would you mind if I took a little extra time to make sure that this lines up with those opinions?
Of course, absolutely not. I would not mind at all. Thank you.
Okay, if people would indulge me, I'd just like to make sure that I'm sure it's 100% perfect, or at least 99.5%. Let me just have 1 month to do that, and we'll put this on for next month.
Thank you for your consideration. All right.
Thank you. The next item is 2022-15, a proposal to amend practice book section 7-19. Attorney Del Campo.
Yes, Your Honor. This was a proposal by Judge Bellis in her position as CAJ. She recommends that the section 7-19 be amended slightly to clarify that a judge may conduct an ex parte review of these applications for the issuance of subpoenas for witnesses on behalf of self-represented parties. They can either be done in ex parte review, or they can be put on the docket, and opposition, a hearing can be held, and opposition can be taken.
Is there any member of the committee with more experience than me in this area about whether this is a very minor change, or is it more substantive that I'm missing it? Looked pretty minor, but I don't know if somebody has greater or better knowledge than me.
I'll jump in here and just go ahead.
Well,
No, go ahead, Courtney.
We'll start with Judge Farley, and then I think Judge Pearson, Judge Chaplin, did you want to say something too?
Yes, I'll go after those two.
Okay.
Well, I think, what happens now is it's between the self-represented person applying for the subpoena, the clerk, and a judge. And the judge decides, whether the subpoena is appropriate and whether it's an appropriate scope. And the order goes out, and at that point, another party in the case could, if they wanted to, I think, move to quash it or to limit it. And I think what Judge Bellis is getting to is that it may actually streamline things if the application were made in the file and an opportunity to object was given. You know, on the other hand, sometimes these things happen under a real time crunch. So giving somebody the alternative of either, you know, filing it or proceeding as we do now, it's really an ex parte process, at least at the outset. You know, makes sense.
Judge Pearson?
I have nothing further to add than what Judge Farley just said.
Judge Chaplin?
I think it was well summed up. I think the only thing I would add is that it would give the judge more direction if it does clarify that it does not have to be an ex parte first and constituting a two-step process. If it were clarified to know that you had the option of going that route rather than doing the ex parte and either denying it or issuing it and then coming back for a hearing, it would make things a lot easier for the staff reps and the court to give more latitude to how to address it.
Judge Stewart?
I agree with everything that everyone said. I would just want to make for sure that it could be handled ex parte. I mean, in civil court, I don't see as many of these as I did when I was sitting as a family judge, where they, you know, vast majority of the litigants are self-represented. And I didn't need some lawyer to tell me that certain of these things were objectionable. So I would want to keep that right of the, not have people automatically file them on the docket. I would want to keep that procedure where they go to the judge first. And then if and only if the judge thinks it would be useful, putting them on the docket and allowing other parties to file objections.
Yeah, so maybe I'm just thick today, but I'm trying to figure out what this actually does. The proposed bracketed language takes out conduct an ex parte and just changes it to say the judge shall review the application, which may be conducted ex parte. I'm not certain what that actually changes. Am I missing? What am I missing? Judge Farley, you're muted. There you go.
It might not change enough.
Yeah.
You know, it's a step in the right direction. But I think what Judge Stewart is saying, well, maybe the rule should say that, you know, the judge can determine whether or not the application ought to be filed on the record and with an opportunity for parties to object. Something.
We are a 9-member committee, so we can't have 5 people meeting and doing something, but I would accept a group of some lesser number of the 4 judges who've piped up here to have a little working group to maybe do some additional work and bring something back with the input of Judge Bellis, and we can maybe do something a little different. I don't, does anybody want to take the lead on that for me?
I don't mind as long as Judge Stewart agrees to help me.
Okay, I will help.
I'm happy to participate if you need my assistance.
Okay, and so thank you. Let's leave it at that. Judge Chaplin, did you want to look like you were reaching for your mute button?
If I'm needed, I'll be there, but if not, I'll stay in Meriden.
Should we put it down for October, or you want to wait and put it for November and you can come back by then? What time frame? But keep in mind, by the way, nothing, even if we were to vote on it in November, it then goes to a public hearing in May. It's not going to be voted on by the judges until June. So don't put yourself on a super tight time frame if that's not going to work with the rest of your day jobs. So
we could do November, but it seems like we passed a lot of things until November, haven't we?
That's not unusual for September.
Okay, so let's do November then.
Okay, thank you.
I hope 09 will be in November too, as I'm not going to be here in October, unfortunately.
Okay. All right. I think that is all we had on our agenda, unless anybody had anything else, or Attorney Del Campo had anything else that needs the attention of the committee.
No, Your Honor.
Okay. Anything else? If not, I will accept a motion to adjourn.
So moved.
Is there a second?
Second.
Favor say aye.
Aye.
Opposed say no. That passes unanimously. Thank you, everyone, and see you in October.
Thank you.
Take care.
Yeah.